Coming to the next form of cyber harassment on the cyberspace, that is cyberbullying. Even though the term has not been incorporated into the statute book of our country, the term cyberbullying means to harass, threaten, or target individuals, especially occurring among youth in the cyberspace. Here I would like to refer to a study conducted by Microsoft, which ranked India third with 53% of respondents, and these respondents were from the age group of 8 to 17 who have been bullied online on several occasions. As far as cyberbullying is concerned, it may include sending unpleasant text messages, emails and instant chat messages, forwarding confidential emails, text messages or instant chat messages to any other person, creating a derogatory online profile about a student and inviting others to comment on them, taking videos, photographs against the will of a person and posting the same on public domain to embarrass him or her. Even though the term cyberbullying has not been incorporated into any of the statute relating to cyber offenses, the IT Act directly or indirectly refers to offenses such as publishing information, which is obscene, that is section 67, sexually explicit material, section 67A, child pornography, section 67B, and breach of confidentiality and privacy, section 72. On a broader perspective, these provisions to some extent may protect cases of cyberbullying and cyber defamation to an extent. However, having spoken about cyberbullying as an integral part of cyber harassment, I would like to draw your attention to a case which was decided by Supreme Court in University of Kerala versus Council of Principals of Colleges in Kerala and others, where the Supreme Court referred to Raghavan Committee report, which had highlighted the need for preventing the practice of ragging from the educational institutions, which may also include the practice of bullying. The committee referred to the act of ragging as a form of systematic and sustained physical, mental and sexual abuse of fresh students at the colleges, universities and any other educational institutions at the hands of senior students of the same institution and sometimes even by outsiders. If we do an analysis of this particular definition of ragging, which was laid down by the said committee, if we take this definition of ragging as defined by the committee, an interpretation of ragging can be made to the extent of including cases of cyberbullying as well, which may result in immediate disciplinary action against the students concerned and inform the police for setting the criminal law in motion. However, there are major obstacles with regard to dealing with the youth in terms of prosecuting them in cases of cyberbullying. For example, the IT Act 2000 is absolutely silent about any penal provisions or prevention of acts of cyberbullying by students. Second, there are only two relevant provisions under the Act, which are publication of obscene materials under section 67 and breach of confidentiality and privacy under section 72. Apart from that, the Act is absolutely silent about dealing with cases of bullying. Another crucial aspect is that there is no bar set on the age of the users of mobile phones, which is one of the fundamental sources of practices of bullying. Subsequently, a huge number of mobile phone users are below the age of 18 years who end up sending offensive messages to their fellow schoolmates out of fun, and there is no regulation on them. In other words, most of the time they do not come within the purview of the existing laws, be it the IT Act or Indian Penal Code. Apart from this, there are no uniform regulation for schools preventing acts of bullying, especially cyberbullying, like the statutes on anti-ragging prevalent in many states in India. The provisions of the new Juvenile Justice Act also, which was enforced in the year 2015, does not talk anything about the issue of cyberbullying. At the same time, cyber cafes need to have stricter regulations while operating their cafes so that such misuse of internet can be curbed to a great extent. There is also a responsibility which can be imposed on the school and college authorities to come up with educational programs to alert for cyberbullying, inform about its potential damage, and thus prevent incidents of cyberbullying. Now, I would like to come to another crucial form of harassment on the cyberspace, that is cyber defamation. Students, you must be aware of the law relating to defamation in our country, as this has already been incorporated as a substantive offense under the Indian Penal Code. Now, when we try to understand the term defamation, it means making or publishing any imputation concerning any person. Such imputation must have been made by words, either spoken or intended to be read, or signs, or visible representation. Such imputation must be made with the intention of harming or with the knowledge or with reason to believe that it will harm the reputation of that person. Now, the question arises as to whether the traditional offense of defamation includes cyber defamation. Now, if we try to compare the concept of defamation as understood traditionally under the Indian Penal Code, cyber defamation means publishing of defamatory material against another person with the help of computers or internet. Thus, if someone publishes some defamatory statement about another person on a website or any social networking sites, or send emails containing defamatory material to other persons with the intention to harm or lower the reputation of the person, would amount to cyber defamation. As far as the legal provisions relating to cyber defamation is concerned, mention may be made of Section 499 of the Indian Penal Code, according to which whoever by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is said to defame that person. And the offense of defamation is punishable under Section 500 of the Indian Penal Code with a simple imprisonment up to 2 years, or fine, or both. If we talk about incorporating the practice of cyber defamation into the concept of defamation as understood under Section 499 of the Indian Penal Code, I would like to draw your attention to two specific words which have been incorporated into the definition of defamation, that is speech and documents in electronic form, which has now widened the scope of Section 499, which is defamation, to include even the cases of cyber defamation. The Indian Penal Code, by incorporating the words signs and visible representations within the definition of defamation, has also included defamation in electronic form as well. In addition to the Indian Penal Code, if we look into the IT Act, even though there is no specific provision as such to deal with defamation, but we may still rely on provisions like Section 67, that is punishment for publishing or transmitting obscene materials in electronic form, Section 67A, which is punishment for publishing or transmitting of material containing sexually explicit act, etc. in electronic form. These provisions may be invoked even though they do not directly mention about defamation, to address cases of defamation in electronic form, which includes sending or receiving of defamatory emails, chat room messages, audiovisual clips, distorted images, etc. on the internet which are indecent in nature. While talking about publication of defamatory material, we may also think about the responsibility of the internet service providers who play a very important role in the publication of the material. In cases of defamation in the physical world, as we know, the publishers are often held liable in the defamation suits because they are directly related to the offense concerned. In case of publications on internet, the website owner and the editor will be held liable if they allow their bulletin boards to carry defamatory contents. Here the issue of the role of the internet service providers come, who control the flow of information and also transmission the information through the network of subscribers. Mention may also be made of provision under the IT Act, Section 79, which provides exemption to intermediaries from liability subject to fulfillment of certain conditions. So, students, in order to understand the cyber defamation from the point of view of its application, I would here like to discuss with you 3 case studies. The first one relates to an online harassment, in fact, a continuous online harassment caused by a PhD scholar from the Harvard University. In 2013, a Harvard PhD scholar was imprisoned for online harassment campaign in order to defame and degrade the works of prominent Dead Sea Scrolls scholars, thereby protecting the works of his father, who is also a Dead Sea Scrolls scholar. To attract more support for his father's views, he devoted years after years creating anonymous online identities and content in the form of emails, blogs, articles, and numerous online comments to malign the reputations and findings of more prominent Dead Sea Scroll scholars. Finally, an FBI investigation was conducted, which led to finding of 51 charges of identity theft, aggravated harassment, criminal impersonation, and forgery. The investigating agency used their simple software that identified the IP addresses and traced the emails and blog posts of 82 aliases to the same few computers. In another case, SMC Pneumatics India Private Limited versus Jogesh Quatra, a court of Delhi assumed jurisdiction over a matter where a corporate's reputation was being defamed through emails and passed an important ex parte injunction. As a result, the Delhi High Court also restrained the defendant from sending derogatory, defamatory, obscene, vulgar, humiliating, and abusive emails either to the plaintiff or to its sister subsidiaries all over the world, including their managing directors and their sales and marketing departments.